Namaskar and welcome to this program. Today I will talk about the fundamental rights and directive principles of state policy, which are contained in part 3 and part 4 of our constitution. As you know, that our constitution was adopted in 1950, 26 January 1950, and directive principles and fundamental rights are considered to be the conscience of our constitution. And this program is a part of our certificate in human rights program. This program is offered by School of Law, and currently it is offered in English and Hindi languages. So if you are interested in the program, you can enroll. Admission will start soon. With regard to fundamental rights, there are 6 fundamental rights in our constitution. Right to equality, right to freedom, and right against exploitation, religious freedom, cultural and educational rights of minorities, and the most important is the constitutional remedy, right of constitutional remedy in case of violation of fundamental rights. So the main characteristics of fundamental rights, if you see the scheme of our constitution, it starts from Article 12 to 35. Article 12 defines the state, and Article 13 talks about the provisions related to the applicable of fundamental rights, that is any law of the parliament or the state legislature should be in conformity with the fundamental rights. So the main characteristics of the fundamental rights are available against the state and its instrumentalities. So this is the first characteristics. And Article 12 defines the states. States in simple terms, we can say that union, the center, states, municipalities, and other bodies, and also the organizations or the corporate bodies which are substantially owned or controlled by the government. So any even a commercial, even the public, even the commercial activity of the state, where the state holds majority shares, or state has the control over the management of the organization, then it is considered to be the state. So the state has been given a very wide definitions, and various judgments of the Supreme Court has enlarged the scope of the state. So generally, the fundamental rights are available against the state. So if the states or its instrumentality violates any fundamental rights, then one has the option to go to the High Court and to the Supreme Court. One can directly go to the Supreme Court also. That we will see later. So another thing is no law can take away these rights. As I told earlier, Article 13 says that any law which is inconsistent with the fundamental rights shall be void. So every law, whether it is passed before or after the coming into force of the Constitution, shall be void if it is in violation of the fundamental rights. So there has been a debate in the constitutional circle whether the amendment of the Constitution is also covered by Article 13. So there was a decision in what we call the Golaknath case. It was decided in 1967, and in that case it was held that amendment is also a law. Therefore, any amendment of the Constitution which is in violation of the fundamental rights is void. And in earlier decisions, the Supreme Court was of the view that amendment of the Constitution is not the law in that sense, and the Parliament can amend the Constitution by following the established procedure. But in Golaknath case, the earlier decisions were reversed. But in 1973, in Keshavanand Bharati case, the Supreme Court propounded the doctrine of basic structure, and the court held that any law which is violative of the basic structure of the Constitution is illegal, is unlawful, is unconstitutional. And what is basic structure? Basic structure is not a thing which is, you can say, you can give a exhaustive list as to what are the provisions which are which can be called basic structure. But in simple terms, or the court enumerated some of the characteristics of the constitutions, and in later judgments also, some of the provisions of the Constitution were considered as basic structure. For example, actually there are certain values by which the Constitution is governed, and without knowing about these values, we cannot understand the Constitution. So there are certain principles, certain values, certain ideals which are considered to be the basic structure. For example, democracy, federal structure, secularism, fundamental rights, division of power between states and center, etc., etc. So any law which according to this Keshavanand Bharati case, basic structure doctrine, Any law, whether it is the amendment of the Constitution or any law which is violative of the fundamental rights is which is violative of the basic structure is unlawful. Now, the other point is to be noted that it is a flexible and open to interpretation, so as to enlarge the scope of fundamental rights. So, the way our courts have interpreted these provisions, it has now many of the rights have been read into the chapter of fundamental rights, and even some of the directive principles have also become the part of fundamental rights, and also various the rights contained in various human rights conventions, ICCPR, ICESCR, CEDAW, Child Rights Convention, Convention on the Rights of Persons with Disabilities, and other conventions, so have also been made part of the fundamental rights by interpretation. Now, as I told you that there are 6 fundamental rights. First is the right to equality, and Article 14 says that no person shall be denied the equality before law and equal protection of laws. In simple terms, it means that any law which differentiates, which discriminates between one person and another person is unconstitutional. Everybody is equal before the law, whether it is an ordinary citizen or a person holding a high position. However, the laws can be made for a class which can be distinguished. But there should be an intelligible differentia, and the nexus sought to be achieved by such differentiation. For example, you can say that certain laws can be made for the urban people or rural people, applicable to them only, or laws can be made for the companies or for individual, or for a particular group, if their conditions are different and they need a different legislation, then that can be made. But this should not be discriminatory. And also, the Supreme Court in A.K. Royappa case and thereafter has enlarged the scope of Article 14, and now it is not limited to classification doctrine only. Now, non-arbitrariness has also been made part of Article 14. So, any law should be just, fair and reasonable, and it should not be arbitrary. So, and it has also become the part of Article 19. Now, Article 15 and 16 talks about the these articles says that no citizen has every citizen has the right to access to public places without discrimination on the grounds of caste, race, sex, religion, place of birth, etc. And also no discrimination or distinction can be made on these grounds with regard to public employment and appointments. So, public employment, public services, in public services, there cannot be any discrimination or any distinction on the basis of caste, religion, etc. However, there are certain points here to be noted. The most important thing is that our constitution talks about the substantive equality, substantial equality, not the formal equality. So, for different groups, special laws can be made. For example, Article 15 says that Article 15, Clause 3 says that laws can be made for the benefit of women and children. Similarly, special provisions and reservations can be made for socially and educationally backward classes of society, now economically weaker sections of the society also, and scheduled caste and scheduled tribes. So to provide them the level playing field, the special provisions can be made in favor of them. So and also Article 17 abolishes the age-old evil of untouchability from our society. So any form of untouchability is prohibited. And Article 18 prohibits any title on the basis of status, Rai Bahadur, His Highness, which was various titles which was given by Britishers. Now the title based on merit, based on the achievements in the society, for example, Bharat Ratna or Padma Awards, or different types of awards which are given on the basis of the contribution in the public life. These are not prohibited, but the titles on the basis of status, etc., are prohibited. Now, with regard to the freedoms, Article 19A talks about the various kinds of freedom. Article 19(1), the freedom of speech and expression, peaceful assembly, freedom of association, movement, and residence, and trade, to carry out any trade or profession. But these freedoms are not absolute. Reasonable restrictions can be made in the interest of the society. For example, with regard to freedom, freedom to incite offense, freedom, I mean, speech which incites an offense, or speech which involves contempt of court, or which affects the speech and expression which affects the friendly relations with other countries, or defamation of a person. Similarly, the movements can be restricted. For example, no person can be allowed to reside in, for example, you can say military areas, or in the tribal areas for the benefit of tribal people. The movement and residence of outsiders are restricted to preserve their cultural identity. So various kinds of restrictions can be imposed. Similarly, with regard to trade and profession, government can prescribe certain requirements to carry out any business, certain qualifications to carry out any profession. For example, for medical profession or for legal profession, one must have a degree from a university, so that the qualified people who know the things, people who have developed expertise in the area, can enter into the profession. So this is freedom which is subjected to reasonable restriction. Now Article 20 talks about the protection against ex post facto law. Ex post facto law means that any law, no law can prescribe the punishment before its enactment, from the date prior to its enactment. For example, suppose a parliament passes a law and makes a particular act an offence. So if the person has committed that offence 1 month back, that person cannot be tried for that offence, because when he committed that act, that act was not the offence. Similarly, if there is a punishment for, say, 3 years for a particular offence, and from today Parliament increases the punishment from 3 to 5 years, and the person who has committed the offence 1 month back, for that person only maximum 3 years punishment can be imposed on him, not the 5 year, because when he committed the act, there was the maximum punishment was 3 years. But legislature can reduce the punishment. There is no bar in reducing the punishment. Reduction of the punishment can be made retrospective, but increase of the punishment cannot be made. So this is related to criminal law only. This ex post facto law prohibition is related to criminal law only. It is not applicable to civil law, and so any law which is not a criminal law can be made prospective as well as retrospective. So double jeopardy means that a person cannot be punished twice for a same offence. A person cannot be tried twice and punished for the same offence. So for example, a person has committed an offence and he was tried in the court, and court has awarded a punishment. And so for the same offence, that person cannot be tried again. If he has committed another offence, or he has committed the same offence second time, then that is a different issue. But for the same thing, he cannot be punished. So, right to life and personal liberty, Article 21. Personal liberty is right to life. The court has interpreted it in very wide terms. That life does not mean mere animal existence. It means a meaningful life. For example, right related to health, education, shelter, clothing, accessible environment, digital accessibility, digital accessibility for all sections of the society, clean environment, public road, etc., right to work. So this is a very wide article, and the way court has interpreted it, it has enlarged the scope. So now, since we have limited time, so now next is the right against exploitation. It covers mainly two things, and that is a person cannot be employed in hazardous industries, a person up to 14 years of age, and it also prohibits human trafficking. Now, religious freedom, every person has the right to practice, profess, and and propagate religion. Restriction, I mean, the secular activities can be regulated, and the laws can be passed for the purpose of social reform and opening the temples. Now, with regard to Article 29 and 30, it is Article 29 says that the religious and linguistic minority has the right to preserve its language and script, and Article 30 talks about the right to administer the educational institutions. The minorities has been given the right to administer educational institutions, but it can also be subjected to reasonable restrictions, qualifications, etc. So Article 32 talks about the constitutional remedy. If a fundamental right is violated, anybody can approach the Supreme Court directly, and Supreme Court issues the various writs for the enforcement of fundamental rights. So since we have limited time, so we wind up our today's presentation. Thank you very much.